you talked quite a lot about sequencing, and actually one of the frustrations that we've certainly faced is the common phrase, and a literal phrase we've heard from international actors is "justice can wait," and that is literally a literal phrase. And for us, it's frustrating because it's almost this dichotomy of a sequencing in terms of prioritizing security and stability, but then at the same time rushing the Constitution. And it's almost as if the Constitution is a box that must be ticked in this toolkit, and it's the token gesture towards justice, because we're saying, oh, we're putting in this framework for you, and so then you can work with it. But I guess my question to you is, in the Libyan context, we're seeing the Constitution becoming almost a part of the toolkit as opposed to an outcome of the transitional process. And for me, that's a very dangerous compromise to use as the Constitution. So maybe you can elaborate a little bit about the way a Constitution can be used or abused in a transitional process.
Looking at the watch, I am particularly worried about giving any long answers. So let me try to be very, very brief. I have already spoken much more than I should have. The danger, as with the justice measures, is that the Constitution will be taken as an instrument of turn-taking. And when a Constitution is drafted in the midst of conflict, it is almost inevitable that what it will represent is the balance of power at the time. Conflict is not the sort of condition that invites impartial deliberation. Conflict is engaged in by human beings for a complicated set of reasons, but one of them certainly is a failure of communication. The perception that argument is no longer useful, usually erroneous, but nevertheless a fact. And under those conditions, the idea that one will articulate a framework in which everyone will feel included is virtually impossible. If people had the ability to think in another regarding fashion, they would not have been in conflict to begin with. Let's be perhaps a bit simple-minded, but realistic at the same time. So again, I think it's remarkable how little the international community learns about this. I mean, the tendency to think about democracy solely in terms of elections, for example. The tendency to think about constitutions as basically a project in institutional engineering, as if it did not embody other values and other dimensions. It is remarkable. We have been down this road in many different countries around the world, and the results are always unsatisfactory. And what is particularly frustrating is that, again, I want to insist, this is a false dilemma. South Africa did not feel that the only options was to preserve the apartheid constitution or to adopt one in 1991. Poland did not think that the only choices it faced in 1989 was to keep the old communist constitution or to adopt one in a rush. It did something, in fact, in some ways analogous to South Africa. It adopted what it called a small constitution, which was basically a reform of the old communist institution, erasing the primacy of the Communist Party and outlining the very basic outlines of divided powers. But it understood that it was going to need a long time to draft a constitution with a participatory method. And therefore, it postponed it. And only years later, it adopted a full constitution. It seems to me that this is something that post-conflict countries should explore much more seriously.
I'll abuse my privilege with one more question. You alluded to this concept of a toolkit with transitional justice, that people, these are your tools and you use them. In fact, I've seen manuals of transitional justice that are marketed. And one of my early memories of being in Libya was this effectively plane load of experts landing within months of the end of the fall of the Gaddafi regime, purporting to effectively market a transitional justice mechanism. And a really odd moment was in a meeting room saying, well, you know, once this is successful, well, you can make a really good living out of this, was a piece of advice I was given. And for me, I think this monetization or this industry that was created out of transitional justice is actually giving it a very bad name, because it is that copy-paste approach that we see to the transitional justice process and the lack of nuance in it. And so I was just, for me, what I guess is, must there be a deliberative way of doing things? Or, you know, where is the room for nuance, or is there room for some kind of innovation when even the, you know, the title of your mandate almost prescribes that you have these 4 elements for it to be, you know, that's what you need and you must tick these 4 boxes. So how do we move away from that in a context like Libya, where, you know, one of the first PSAs I saw on television was explaining to people what transitional justice was, and, you know, in March of 2011, we started the revolution in February, sorry, in March 2012, so a year later. Yeah. And so for me, it's thinking about this term that's being used, but also what the reality means and what losses we might have in the pursuit of a standardized format of it.
So, again, trying to be brief, and of course I'll be very happy to discuss. To be fair, this is a problem that afflicts not just transitional justice, but work in general. No? So economists have a name for this tendency. They call this isomorphic mimicry. Now, the tendency to think that the very same institutional form will work under all circumstances. Think about, for example, the fate of anti-corruption commissions. Once the world came up with the idea of an anti-corruption commission, then the model was propagated all over, regardless of cultural circumstances, economic habits, all sorts of things that are, of course, absolutely fundamental to the nature of the existence and the modalities of corruption. So the same model was assumed to work everywhere. So I think that, to be frank, part of the reason for this is sociological. The process of professionalization, in which all of us here, to some extent or another, engage in, is a process that requires students to demonstrate competency with respect to the existing literature. And the existing literature, of course, once a field consolidates, it means that it has some paradigms. So people are tested on competency with respect to a pre-existing way of doing things. And therefore, it is very likely that the next case they will treat in exactly the same way that they have been educated to deal with problems of a similar type. Now, part of it is a great blessing. No? It's part of the manifestation of the fact that we learn, and the steepness of learning curves in transitional justice process obey this thing. The pitfall, however, is that we get used to the idea that there is a formula. And that is what I do not think works. Now, the fact that transitional justice can be described as having these 4 core elements, truth, justice, reparations, and guarantees of non-recurrence, I do not find objectionable. What I find objectionable is that the fundamental question that countries then start asking themselves is, what is the best way of establishing a truth commission? What is the best way of establishing a reparation program? In other words, fixation on the institutional forms again, rather than trying to raise the question, what is the most effective way of giving life to the rights to truth, justice, reparations, and guarantees of non-recurrence? That should be the fundamental question. And in different contexts, the institutional formations may look very different. But I think that that's the sort of thing that we should be worrying about, not how do we establish a truth commission here. In April of last year, I went to the Gambia, where incidentally, I think that a truth commission would work very well given the characteristics of the case. But I had a meeting with the Council of Ministers, and I asked them, how did you come up with the idea of a truth commission for the Gambia? They looked at one another until one of them said, well, isn't this what we are supposed to do? It's that sort of thing that I think we should avoid. I think that we ought to be clear about what is it that we try to accomplish, what are the relevant rights, and how best to satisfy them.
I will not ask any more questions. I could just be here the whole night. I'll open it out to the audience. If I ask that you kindly introduce yourself briefly. I'm looking for questions and not interventions. We're here to hear from Pablo. I'm very happy to hear people's views at the reception afterwards. I have been told by my team to mention the hashtag several times, but I'm too old to remember this. So it's hashtag Annual Justice Lecture 19. It's being streamed live, so we do have questions from Facebook for you as well. I feel so modern saying that.
Yeah.
It's really quite satisfying. So I'll open it up now. So I might take a group. There's a gentleman there with the purple tie.
Thank you. My name is Richard Timmis, and I'm a solicitor. I practice in human rights, but my question is really about South Africa. And with South Africa, we are now 25 years beyond the conflict, or more or less beyond it. And we had a Truth and Reconciliation Commission. And my question is, how do you rate the success of that, looking back 25 years? And where do you think South Africa has got to on the governance scale that you mentioned in your talk?
Great. I'm going to try and see if we can get a few. There's a lady here. And then there's a lady up at the very top.
Thank you for the presentation. Veronica Inestrosa, International Bar Association's Human Rights Institute. So you mentioned that transitional justice requires time to achieve transformation, but when could one claim that a transition is over? When could one say that a country can go back to its ordinary measures?
Okay, I'll take that last one.
My name is Leila Eludat. I'm a lawyer. I have two questions, please. My first question is, since international law has been put from a male-centered perspective, and grave human rights violations do not necessarily take into consideration experiences of women or the disproportionate impact of the conflict on them, could you tell us about transitional justice that actually works for women? And my second question is about the transformative nature of transitional justice, especially when restitution risks putting certain groups of people in a disadvantaged position, and when transitional justice can be used to make serious changes to society. What developments has been made on the transformative function of transitional justice? Thanks.
So let me take them in reverse order, if I may, and very briefly, but I won't be able to do full justice to any of them, but just make a few remarks about this. First, on the gender thing. I do not want to claim by any stretch of the imagination that this is something that transitional justice has figured out completely, but I do think that the great progress has been achieved in taking women into account in transitional justice measures. Let me illustrate this very briefly. The first set of truth commissions had absolutely no notion of the importance of any sort of gender considerations. They were gender neutral, not by design, but by, in a certain sense, this was how things were done, and that meant that, as you correctly point out or imply in your question, women were left aside. The Peruvian Truth and Reconciliation Commission, for example, was the first commission that had a gender unit that tried to mainstream gender considerations in the work of the commission, and I have to say, with some success. In many ways, perhaps surprisingly, the Moroccan Truth Commission made huge strides with respect to gender considerations, including the fact that, from my perspective, it is the most gender-sensitive reparations program of any program. And I said that to some extent it may have been surprising because, for example, in the first session that I had with the plenary of the commissioners, 16 men and 1 woman, by the way, I asked them for their preliminary thoughts about how to deal with gender issues. And one of the men raised his hand and said, Monsieur de Greiff, this is a Muslim country. We have no such problems. And I said, I am not a country expert, but if what you are telling me is true, it would make of Morocco a total outlier in terms of human rights violation anywhere in the world. That was the starting point. The end point was a program that, departing from Sharia with respect to the distribution of benefits, it benefited not just female victims, but female family members of victims in a way that no one expected, took them into consideration in many different ways, in a way that really makes the program the most gender-sensitive reparation program of any of the ones that I'm familiar with. So we have learned quite a bit. Again, I do not want to overstate the case. I just want to say we have come a long way from the beginning. On the transformational side of transitional justice, again, I want to avoid extremes of both cynicism and romanticism. I think that we ought to be very realistic about what we are talking about with respect to the transformative potential of measures that are weak in the ways that I indicated before, and in many other ways, including the fact that they are invariably ad hoc measures. They are not part of an enduring institutional network, for example. They are not part of ministries. They do not subside. They exist for a short period of time. They are usually under-resourced. They are usually understaffed. And from a functional standpoint, they were designed for certain things and not for others. There is a question about resource endowment that I think it would be totally naive to ignore. So I did a rough calculation for one of the reports I presented to the Council about this. When the Chilean transition took place in 1990, the Chilean government's income per capita was close to $600. In 2002, when the Arusha Accord was signed for establishing peace in Burundi, Burundi's government received $24 per year per capita. Liberia's government in 2002, when the Comprehensive Peace Agreement was signed, received $12 per capita. And so let's be clear. The Liberian government had $12 per year per person to do everything that our government is supposed to do. Pay credits, interests on the credit, infrastructure investments, education, health, and justice. So I think that we ought to be very clear about what transformative justice can mean in a context like this. Because again, I fear that unless we are very serious about this, we are going to be awakening expectations in a totally dishonest way. I think that the transformative dimension of transitional justice in contexts of that sort, and Libya in many ways is not this because it has resources that other post-conflict countries do not have. But nevertheless, it does have its institutional challenges. I think that the transformative contribution of transitional justice at this level ought to take place particularly at the level of the linkages between institutions, culture, and personal dispositions. That there is great space for making contributions in the development, for example, of a culture of citizenship, making real for the very first time the idea that citizens are rights holders, that it is perfectly all right for them to raise claims against the state. That is hugely transformative. But the idea that transitional justice will take people from hell to heaven in a short trip, I don't think that that has worked ever. And nevertheless, I think that there is transformative potential that ought to be stressed. Veronica, your question. One of the advantages of the very long title that the mandate had was that it allowed me to escape the burdens of questions about the beginning and the end of a transition. So in this respect, I think that the Council was wise. Transitional justice is a terrible term for many reasons, not just because it invites questions of this sort that are very difficult to resolve. It also suggests that transitional justice is a special kind of justice. And this is something that I totally and absolutely oppose. I think that transitional justice describes a set of strategies for achieving perfectly familiar conceptions of justice under very difficult circumstances. Not that it refers to a special sort of justice, particularly a soft form of justice. So I think that we should, in a certain sense, try to leave that question aside and concentrate on giving reality to rights, acknowledging that under some circumstances that's a particularly difficult thing to do, but the right to justice, truth, reparations, and guarantees of non-recurrence are the core of the concern, not the transition. And finally, with respect to South Africa and its Truth Commission, I think that the Truth Commission played a very important role, first in the development of the field. I mean, there is absolutely no question that the South African Truth and Reconciliation Commission is one of the most important commissions ever. However, there is a downside to its having constituted itself as a model. It gave the impression that truth commissions are an exchange for legal amnesty. And in fact, only of the more than 40 truth commissions that have existed around the world, only the South African Truth and Reconciliation Commission had this function. And the function was actually much, as you know, much more sophisticated than a pure truth for amnesty exchange. Different committees were responsible for making determinations about amnesty. Of the more than 8,000 requests for amnesty, fewer than 700 were granted. Those people should have been were open to prosecution. And in my view, some of them should have been prosecuted, and I think that that would have changed our understanding of the South African Truth and Reconciliation Commission. The question about governance is an interesting one. What's the connection between these things, the transitional justice measures, strictly speaking, and changes in governance? I think that it is very difficult to make a direct link. The measures, after all, were not designed for this purpose. But I want to say that in other contexts, for instance, in the case of Guatemala, that tried to prosecute former General Rios Montt unsuccessfully, as it turns out, in the end. But nevertheless, he had to submit himself to a trial. And for people who were used to thinking that the law was only for the poor and that no one with power had to submit himself to the discipline of a court, seeing this, seeing a judge tell the former dictator, it's not your turn to speak. No, you cannot say this right now. No, you cannot address me in this way. In other words, a visible representation of the rule of law. I think that this is very significant. That it is one of the things that makes people acquire a self-understanding of rights holders. And I think that this is fundamental.
I think we can do a couple more questions. I know there's one up there, and then there's a lady in the middle there. Sure. Sorry, the collars of the seats are really playing with my lips. Are there any more hands up that I've missed?
Hi, Amir Al-Salman, international law master's student. So my question for you is about a case which is Lebanon. And Lebanon, after the civil war, it hasn't been able to move on in a certain sense. And the idea of transitional justice has not been able to manifest because of political constraints. So my question is, how can someone, or how can you in your position try and move towards the general idea of transitional justice when you have a lot of political constraints and political liabilities, in a sense, that prevent transitional justice from occurring? Thank you.
Thank you.
The lady with the pink hair.
Hi, I'm Rayhan. I'm just an engineer. My question is, in my opinion, a lot of what has happened in Libya has happened due to outside intervention. So a way of getting more transitional justice would be to empower the Libyan people themselves to put in your 4 fundamental strategies. So how does a country like Libya, who have many people who are interested in our resources, how do they stop that, and how do they empower themselves and enable themselves to transition, like to have that transitional justice without the outside intervention, I guess.
And one final, there's 2, one there. Elise, do you want to grab the one from Salim? And Inish, right here. So we'll do these 2.
Yeah, Salim El Mayara, I'm a council member of the Society for Libyan Studies here in London. Thank you very much, Paul, for the informative and useful talk. We found it very enlightening indeed. 2 quick questions for you. One refers
one
to
question, we're really tired.
Amir,
so pick your favorite.
which is okay. Has there been any country that achieved transitional justice without a constitution, consensus on a constitution and a security? And very quickly on Rwanda, I don't know if you're familiar with it.
No. Really, did you think you'd get that past me?
What's the magical bullet? Is it applicable to Libya? I don't know.
No, we're not doing that question. Raima, over to you.
It's just maybe me bouncing back on the question that was asked by the engineer. I just want to ask, actually, because you mentioned the interconnectedness between the policy goals of foreign states and also the security development and development, etc. But even the issues that supersede sometimes justice or transitional justice, like, for example, counterterrorism or immigration, they're still approached on an ad hoc, short-term basis. So how do we expect transitional justice to first be at the forefront, and second of all, also be looked at in the long term, from a long-term perspective? Because often what the actors that state support are often the ones that repress civil society in the first place. So that's a bad loop for approaching transitional justice in any way, even from the ground.
So thank you very much for the questions and for your kind comments about my very long intervention. So a few comments again, I'm sure that I will not be able to respond fully, but there is a question, for example, in the case of Lebanon, and generally speaking, in the case of places in which there are lots of political constraints. I, of course, wish that I had a magic bullet, and someone said, in my position, I no longer have any position that allows me to do anything more than engage in discussions of this sort. But there is a sense in which one should perhaps take some consolation from the fact that again and again it is shown that these sorts of problems do not go away. People do not forget. And this is true regardless of background, tradition, religious or legal preferences, developmental factors. People refuse to forget what happened. And that means that either now or in 15 or in 30 years, the issue comes back to the agenda. The Spanish Civil War concluded in 1939, and Spain is still mired in debates, including legal debates, about the end of the conflict. So there is a sense in which if leaders were wiser, they would understand that it is better to deal with these issues head on, to do it earnestly, that people in the end, I have never met victims that have completely outrageous, inflated expectations. Of course, there are victims that are poorly informed about what is feasible. But there is no transitional justice process that I am aware of that has been derailed completely by by obstinate demands on the part of victims. The needs of victims are actually, in most cases, satisfiable. The position of government that this is too difficult, that it is too expensive, with all the governments that I have ever worked with, the starting point, for example, with respect to reparations has been, oh no, we cannot afford this, this is too expensive. So I ask, how did you come to that determination? And show me the basic accounting that you have done, the basic calculations of the costs. And it turns out that they never do it. They just assume that this is too expensive and that it cannot be done. In fact, it can be done. And the political economy of reparations, for instance, is interesting. There is no close correlation beyond a certain threshold, one has to say. There is no close correlation between national wealth and munificence in reparations. There is a close correlation between political organization and successful reparations, but not necessarily wealth, again, beyond a certain threshold. So I think that this is the general lesson that I would like to draw. There is very little that can push a totally recalcitrant government to do certain things, except that now international pressure is becoming more and more active in this sense. No? There are expectations pertaining to this. Lebanon, cases like Lebanon, I think, in a certain sense, because of temporal considerations, and also partly because of geographical location, have fallen off the cusp. We are talking about some of the violations in Lebanon took place, in a sense, before the paradigm really took shape internationally. Spain is, for example, in the same category, and to some extent, the UK, which I visited officially with respect to the Northern Ireland conflict. So these are cases that, at least in part for temporal reasons, are not the main focus of attention. But the main point I would like to stress is people do not forget. The problems do not disappear, and therefore they will come up in one way or another, no matter what a government wants to do.
We're being prompted to wrap up, but I'd like to deal with very quickly with the question about sort of international interests in Libya and the question of the role of a constitution in transitional justice.
Yeah, so on the former, I think that there are some countries that are cursed with being the object of a great deal of geopolitical interest. And not surprisingly, there is some correlation between things like oil and that sort of interest. And of course, that doesn't always help. The agenda of the international community is not always coherent. It's often at cross purpose, and increasingly so these days. So even a country with very little geopolitical interest from an economic standpoint, like Burundi, for instance, where I also worked a great deal as a special rapporteur, the Security Council has been incapable of coming to an agreement about press releases, not resolutions, press releases about Burundi. And the reason, of course, is that a discussion about Burundi, which really has very little economic interest to anyone. The total direct investment in Burundi, foreign direct investment in Burundi in 2016 was $8 million. That's less than a corner Starbucks in London, I assure you. So this is not of great geopolitical interest, but because of how the dynamics within the Security Council have developed, they cannot agree on a, I'm sorry to use the word, freaking press release. Not a resolution, a press release. So with respect to a country like Libya, where there is something at stake by comparison in economic terms, I think that in that respect, it's going to be much more complicated. And that for that reason, it is particularly important for Libyan civil society to exercise as much control as possible over the situation, and there is no way of doing that in the midst of total fragmentation. Libyan civil society has to come up with basic understandings about where they want the country to go before they can resist international intervention. And finally, on the question of the constitution, actually, numerically speaking, I would say that half of the countries that have implemented transitional justice measures have not engaged in very deep, thoroughgoing constitutional reforms prior to the implementation of the measures. Have not. So again, I think that there's a lot that can be done in the domain of justice without an entirely new constitution. Ultimately, I want to insist on the point I made during my intervention. The issues are interrelated, and both stand to gain from being thought about together. But there is a lot that can be done before the adoption of a new constitution, and I want to insist on the main point with regard to this. It seems to me that the adoption of a new constitution in the midst of conflict is a fundamental and unnecessary mistake.
Thank you. So there is a reception across at Senate House, and people can direct you. Please do join us, because we've ordered quite a bit of nibbles and drinks, and I certainly don't want to take them home. But all that remains for me to thank you so much for making the journey, a very long journey from Bogota to here and then back to New York tomorrow. So we're very grateful for your time. I want to thank SOAS for being a wonderful partner in this process, the audience for being here and engaging with us, the LFJL staff who've done an amazing job preparing for this,
yes,
I think, and also in running it today. And if I may take a moment for people who aren't in this room, our partners in Libya, who we get a lot of credit as LFJL for the work we do, but we're only strong because of the incredible network of NGOs that we work with in Libya who really do the hard lifting for us. So they're not here, but that does not mean they're forgotten in this evening. So thank you to everyone, and please come join us and share with me a round of applause for Pablo.
Thank you.